A very good evening to all my dear students. We welcome you on behalf of ICAI for the third session of chapter Management and Administration CA Intermediate Law. Welcome to the class, students. Good evening, Khushi Mehra, Sangeeta Vanan, Soumya, Rajveer, Almas. Yes, Soumya, even I am happy to see you all back in the class. Miss Naina, all of you, a very warm welcome for today's class. So I hope you have revised what we have done in the previous class. We have already completed from section 88 till around section 100, I believe. We have completed about the register of members, about the AGM, annual general meeting, and extraordinary general meeting was also done in the previous class. Also, we have done certain questions related to these topics. So in today's class, we'll be starting with a very interesting topic, that is prerequisites of a meeting. Whenever any meeting is to be done, what are the requirements for that meeting? As I briefly explained to you in the first session, that what are all the requirements for calling any kind of meeting. So this is all we have done. Section 88, register of members. What is MGT2 form? Can anyone tell me? Let's have a quick revision and test and a recap of what we have done in the previous classes. What was MGT2 form? We have seen the forms also. I remember showing you the forms. Excellent. It's the form for the register of the debenture holders. Very nice. Good, students. And which form is used for the foreign register? Which is the form used for foreign register? MGT3. Excellent. All of you, and within 15 days, the entry was to be made in the main register whenever the entry is made in the previous register. All right, then section 89 deals with the beneficial ownership interest. We have done that. How many days are given for filing the beneficial interest? And how many days for filing it with ROC for the company? 30 days. Both the provisions are 30 days. And then we did the penalties. I told you how you have to write the penalties with respect to each section. Anyone who remembers the definition of significant beneficial owner under section 90, who is SBO? That is a significant beneficial owner. So the thumb rule was to remember the word 10%, holding not less than 10% of the share capital or 10% of the voting rights, or having the right to receive not less than 10% of the dividend, or he is exercising directly or indirectly any significant influence or control, then he is known to be a significant beneficial owner. And then we did all the Ben 2 form, Ben 1 form, Ben 4 was used when the company is submitting the submission for significant beneficial owner. All those points were done. Then we started with a very interesting and important topic, that is annual general meeting. So what is the gap between two AGMs? Is it 10 months, 8 months, 15 months, or 20 months? What is the exact gap that should be between? It should not be more than 15 months. So the maximum cap is 15 months. Excellent. And when should be the first AGM held for the company? For any company, the annual general meeting, the first annual general meeting should be held in within 9 months of what? From the close of the first financial year. Ishan, Almas, Anushka, Nidhi, wonderful answers. Shailaja, Rajveer, Sandeep, all of you, Sunil Kumar, Almas, Rajveer, Khushi Mehra, excellent. All of you have given wonderful answers. Harshada, nice. It is not necessary for the company to hold the AGM in the year of incorporation. True or false? Is this statement correct? It's not necessary. So as far as you're complying with the 9 months provision, it is okay if you have not held it in the year of incorporation. What is the subsequent AGM time period? Naina, Nidhi, all of you written true. Well, yes, Ishan, Shailaja, Sunil, 6 months. Can I extend this period of 6 months? Oh my God, wonderful answers. Yes, ma'am, but not beyond 3 months. Very good, very good. So, Mesh Singh, Khushi Mehra, Naina, Sunil, Rajveer, Priyanshi, Miss P. None of you have given the wrong answers. Everyone has given the correct answers. So, applause for all of you. Meeting you after 4-5 days and still having the recap and making sure that you all remember the answers, phenomenal. This is really great. So this is how you have to keep your spirits high, keep revising, keep studying. Don't give yourself a single gap. Once you keep any topic or any chapter pending, trust me, it keeps on lying pending. So keep on doing along with the teachers, keep on making your notes, keep on revising. Consistency is the key to success in your CA journey. You have to be very regular with your studies. Then this was the time and place of AGM, very simple. Any default, tribunal will be called for the meeting. When does the tribunal get the power to call AGM? When does the tribunal get the power to call the AGM? Tell me. When will he get the power to call the AGM? If the default has been conducted in holding the AGM, then any member may make an application or tribunal may call the meeting, and such directions can be given for calling the annual general meeting. Why are you saying board? Who is holding the annual general meeting? Is it the board of directors or shareholders are holding? Yes, who has written this? Rajveer, members, yes, good. Okay. So if your general meeting is not held or if the articles permit, tribunal will call and give directions for calling the annual general meeting, and such meeting should be called as per the directions of the tribunal. In today's class, when we will be doing proxy section 105, we will be giving reference to section 97. Can anyone tell me why? Was there any provision that we did in case of section 97 relating to, very good Sandeep, you are correct, Gokul. So many new names I can read today and everybody is giving the correct answers. Wonderful. Soumya, Rajveer, very good. Priyanshita, yes, she's writing, ma'am. If something is pending, it keeps on lying pending. So you should complete your work, children. It's very important. Okay. Any member or proxy, Miss P, excellent. Yes, Rajveer, good. So here, even if one member is present in person or by proxy, then also the meeting shall be conducted. It will be assumed that as if the AGM of the company has taken place. So section 97 and section 98 are the only exception. I repeat, section 97 and section 98 are the only exception where even one member or one proxy is present, still the meeting can be held. Otherwise, section 103 laid down the requirements for quorum, how many members to be present, but 97 and 98 are the only exception where only one member is also present. They can conclude the meeting. Please write down in your notes. Section 97 and 98 are the only sections which give the exception where even one member is present, he can hold the meeting. This is the meeting to be held by tribunal. All right. Yes. After that, we did section 99. Can anyone remind us what is section 99? What was the penalty if any default is made? Let me see who are the students on the portal also. Very good. So what was section 99? Penalty if the meeting is not held as per section 96 or as per section 97, directions given by the tribunal, or if EGM is not held as per the tribunal, then the penalty will be 1 lakh for the company who is in default. What was the penalty? Every officer and company who is in default shall be punishable with a fine of 1 lakh. And when the default continues, 5,000 rupees for that per day default which continues. Is that clear? After that, we have started with section 100. where we did extraordinary general meeting. So फटाफट से revise कर लेते हैं. Extraordinary general meeting. What is the requirement? Board will call the extraordinary general meeting. Yes or no? Yes, ma'am. First point. I remember making you note down points also for this. So board will call EGM. If board has not called, then who will make the request? Tell me the requisition to be made if the company is having share capital. Who will make the request? How many number of members shall make the request? 1/10 तो ठीक है राजवीर, बट बहुत सारे केसेस में 1/10 आएगा. ईशान, सौम्या, क्या 1/10 of what? Members holding not less than 1/10 of the paid up share capital of the company. So at least 10% of the paid up share capital should be the word. Nana is saying directors. So beta directors will hold EGM. But if directors do not hold, then requisition is made by company having share capital, at least 10% of the paid up share capital holders. If company is not having share capital, then at least 10% of the total voting. Requisition will set out what are the matters to be discussed. Today, we will be discussing in detail about these matters when we do notice. Within how many days the board shall call the meeting? Within how many days the board shall call the meeting? 21 days of what? 21 days of the valid requisition received. And what are the maximum days? But the meeting should be held not later than 45 days. Means 21 से 45 दिन के बीच में meeting should be conducted and convened. So calling of EGM requisition can be given in writing or electronic mode. How many days before you have to give the notice? I told you 21 days. Today we will be discussing about all these notice things. Have we started notice or we are yet to start notice section 101? Tell me. Did we start? I think we did till EGM, right? We did till section 100. Okay. So we'll be starting with notice. Notice shall be signed by all the requisitioners. No explanatory statement is required with the notice of EGM. They may disclose the reasons for the resolution to be passed. I told you there are certain things where you can give the reasons. So no explanatory statement is necessary. So today we will discuss section 102. What is the explanatory statement? And section 101, what is the provisions related to notice? Yes, Nidhi, we will be covering all these topics from the study material also, so don't worry. So now these are the requirements of the meeting. Section 101 tells you about the notice to be sent. Every meeting, I told you what is the meaning of notice. Let's go back to our schools. So whenever the schools were there, when we were studying in a school or a college, the notice board pe notice lag jata hai that your annual function is going to be held on this date, or some books need to be contributed. So you have a notice, means information about that. So something needs to be concluded or conducted. All the public of school or college, all the students over there needs to be informed. So we try to use the notice. Yes, Soumya, excellent. Holiday announcement. That's correct. And then explanatory statement. 102 is the explanation to be given with certain notices. So today we will understand how the notice for AGM as well as EGM is sent and what are the cases where the explanatory statement needs to be given. I remember doing ordinary and special business discussions with you. Khushi Mehra, yes, I can also recall something. Meaning of explanatory statement, Nidhi, hum karenge abhi. Okay. Don't worry, we'll do it again. Don't worry. So first is notice, second is explanatory statement, third is quorum. Quorum means minimum number of members who shall be present for the meeting. Then out of the quorum, अब देखो हमने notice भेजा कि सारे बच्चे function के लिए आ जाए. Explanatory statement, ये मैं आपको general समझा रही हूँ. It's not the companies. I'm just trying to relate it with your school times so that you can recall, you can have a visuals in your mind that okay, like this notice will go. Explanation will be given where the stalls have to be put up. Quorum for the meeting means minimum number of members who will be handling the responsibility. Out of all those members, we'll choose a group leader. He is known as chairman. If somebody is not present, then his proxy will be coming. Then we'll be having votings on certain matter that what color we have to choose, how we have to put up the stalls. तो उसके लिए voting होगा. फिर resolution pass होगा. Resolution means decisions. हमने फाइनल डिसीजन कौन लेगा, प्रिंसिपल या स्कूल लेगा कि क्या डिसीजन। सो इस तरह से अगर आप स्कूल की लाइफ को इमेजिन करें तो उसी तरह से जैसे हम कंपनी है, कंपनी नोटिस सेंड कर दिए फॉर द मीटिंग्स, एक्सप्लेनेशन देगी फॉर द स्टेटमेंट्स एंड all right, explanatory statement will be given, and then quorum, number of members, how many should be present, chairman, proxies, and then voting will happen. All these section 106, 110 will tell us how the voting needs to be done, and we'll see how the resolutions are to be passed. Now, one by one, we are going to understand all these topics in detail, starting from the notice of the meeting. Very, very important part is how the notice needs to be sent. In order to call a general meeting, a notice of at least 21 clear days has to be sent, either in writing or through electronic mode. So if I give you MCQ and ask you, children, can we send the notice for meeting through electronic mode like Gmail or WhatsApp? भेज सकते हैं हम electronic mode में, yes or no? So what will you say? Yes, ma'am. We can send the notice in electronic mode also. If I ask you, can we send the notice for the meeting oral? Can we call a meeting by sending the notice orally? No, ma'am. Why? Because it has to be in writing or it has to be through electronic. Can we send the notice at least 7 days or 15 days before? No, ma'am. At least 21 clear days. Now we are going to understand what is the meaning of clear days. So, 21 clear days means the date when the notice is dispatched and the date of annual general meeting is not to be included. Please write down in your notes. The date when the notice is dispatched, the date when the notice is dispatched, and the date when the annual general meeting is to be held, and the date when the annual general meeting is to be held shall not be included, in counting 21 clear days for the notice. In counting 21 clear days for the notice. If the notice was dispatched on 1st October and the meeting was to be held on 15th October, is it a valid notice? Yes or no? Why everyone said no? Because it is less than. No, because it is less than 21 days. Second example. If I dispatch the notice on 1st November 23 and received the and date of AGM is please now tell me, is it a valid notice? Yes or no? Everyone, Khushi, Miss P, Ishan, everyone has given the correct answer. Almas, Sanushka, all of you. Because 21. Dhanush, Rohit, Sandeep, great. Harshida, Shailija, Kirti, excellent, everyone. Very nice. Why? Because it covers at least 21 days. So 1 and 23 will not be counted. So clear cut 21 days have been served over here. So 21 clear days notice has to be given at least 21 days before. You can give more than that also, but 21 days means The date on which the notice is served will be excluded while sending the and the date of meeting. अच्छा लिखा भी हुआ है यहाँ पे मैंने, on which the notice is served and date of AGM is excluded. ये तो हो गया point number 121 clear. Second point, can we give a shorter notice? Yes, in case of an AGM, we can give a shorter notice if at least 95% of the members have given their consent. For AGM, what is the condition for giving a shorter notice? At least 95% of the. Yes, Priyanshi, I told you at least 21 clear days has to be there. So, आप 25 days दे दो, 28 days पहले दे दो, but 21 days पहले देना. Okay, Priyanshi? Minimum days are 21 clear days. All right. So, in case of an AGM, you can give the notice for lesser period. Means I want to give the notice for 15 days or 7 days. So, 95% of the members who are entitled to vote should give their consent. Then yes, you can give a shorter. In case of any other meeting, ये any other meeting कौन सी होती है बेटा? AGM, extraordinary general meeting ही होगी ना? So in case of any other general meeting, that is EGM, what you have to see in case of EGM, company having share capital, or if the company is not having share capital. If the company is not having share capital, then 95% of the total voting power. If the company is having share capital, then 95% of the paid up share capital. Plus, there is another condition. Majority of the members should have consent. Majority of the members should have consent. Now, please write with me. What are the provisions for shorter notice? Number one, if it's AGM, then 95% of the paid up share capital holding consent. Yes or no? Bilkul theek. In case of AGM, what will we do? We'll have two categories. One is company having share capital. Another is company not having share capital. Company not having share capital में किसका consent चाहिए children? Company not having share capital में EGM में requisition में 10% condition थी, notice में 95% condition है. Keep on writing down with me today. We'll make sure that you learn these provisions today in class itself. But keep reminding yourself, for EGM, it was 10% of the provision. For the requisitionist calling the meeting, for notice, it is 95% of the total voting power. 95% of the total voting power. Company having share capital की condition क्या है? 95% of the paid up share capital plus majority of members consent. Majority क्या होती है? Means more than 50% members should say yes for shorter notice. अब इस पे बनता है question. Exam में he is not going to simply ask you, have I given 21 days notice or not? He will give you a question that less than 21 days notice can be given when AGM, 95% of the paid up share capital people are consenting. Yes, Rajveer, 51, बिल्कुल ठीक बोला आपने. Anushka, good. And if companies having share capital, EGM के case में 95% of the paid up share capital plus majority of the members. And if the company is not having share capital, then 95% of the total voting. Now, there was a company having total paid up share capital of 100 crores and total number of members were 200. Consent was given by 90 members holding 98% of the total paid up share capital. Is it valid? For shorter notice, yes or no? And give me reasons also, please. Is it valid? Miss P says not valid. Why? Others also. Take 2 minutes. Read it. Take 2 minutes. And then respond. Very good, Ishan, Nidhi, Almaz, Soumya, good. Let everyone respond. Memory, Rajveer. What is the reason? No, no, to theek hai. Reason kya hai? Okay, Priyanshi, good. Miss P, good. So what should have been the correct answer? Dhanush, Priya Mishra, Shailaja, very good students. Excellent. Because 45 members. Yes, Jiyandra, Nidhi, Priya Mishra, very good all of you. Khushi Mehra, Anushka, Miss Soumya, Rajvi, Memory, good. So at least no is the correct answer. At least 100 members should have given their consent. 95% वाली condition तो meet हो रही है. But majority of the members की condition meet नहीं हो रही है, which means at least 100 members should have said yes for the shorter notice. Okay, let's take another example. If 100 members say yes and they are holding 75% of the paid up share capital, valid or not? ये लिख लेना बेटा सारा एग्जांपल्स अपने नोट्स में. Valid or not? No, ma'am, because now you have not met the condition of 95%. समझ गए? हाँ, intelligent students. So इसका भी आंसर है not valid. Is that clear? Can I raise the board? Yes, Ishan, that's correct. Majority of the members, at least majority. So 100 or more than 100. Can I read? Can I delete it, children? Can I rub it? Have you noted? Okay, Kirti, Priyanshi, thank you so much. See, I'll show you, Ishan. Majority numbers entitled to vote representing not less than 95%. So majority numbers is 100. At least 100 members. Okay, more than majority nahi bola, majority. So more than 100, at least 101 or 100 should have consent. Now somebody is writing, ma'am, 1 minute, ma'am, no. कोई बात नहीं, वीडियो में बैक जाकर देख लेना, रिकॉर्ड हो गया है, ठीक है. धनुष, निधि, संगीता, ऑल ऑफ यू. Every notice must state the date, time, place, and hour of the meeting, along with the statement of business to be transacted. So notice में बच्चे हम क्या लिखेंगे? Where the meeting has to be conducted, what is the date. So remember, when the notice on the school board you put, you always used to write the date, day, hour of the meeting, and what business are we going to do. In our school, what are we going to do? We are going to hold an annual function. So here, what business are you going to do? You'll tell them this is the notice of AGM, that is annual general meeting. Clear date, time, place, and business to be transacted. Easy hai. Notice shall be given to every member of the company, legal representative, or the assignee of insolvent member. Now, what is the meaning of this line? To whom the notice of AGM has to be sent? Priya Mishra, it is the majority of the members should have said yes. Okay? निधि अभी करेंगे मीटिंग कितने आवर्स की है, पहले जो मैं बता रही हूँ वो सुन के. Okay, that's so nice, Sunil. You can do that. Okay. Every member of the company. So notice will be given to every member of the company, whosoever is the member of company. So Mr. A was the member of the company who shall get the notice. Now Mr. A died. So now who will attend the meeting on his behalf? Legal representative of any deceased member. If the member has died, then his legal representative should have been given the notice. Sandeep, we are talking about the annual general meeting of shareholders. Here we are holding the meeting of shareholders. Okay, so members of the company, whosoever is the shareholder will get the meeting. Directors will also be given. I'm explaining you point number 1 about the members. Okay. Legal representative in case the member has died or if the member has become insolvent. What is the meaning of insolvent? When you don't have sufficient assets to pay off your liabilities. When you don't have sufficient assets to pay off your liabilities, then who will get the notice? Your assignee. Assignee is appointed by the court, who will now get the notice for this meeting. Point number 2 is auditor or auditors of the company. Who will be given the notice? Audit or the auditors of the company. So whosoever is the auditor, he will also attend your general meeting. What are you doing? What is your discussion? How is the meeting going on? He also has a right. He might attend, he might not attend. Chapter number 10 में जब auditors पढ़ोगे, तब आपको बताया जाएगा. He has a right to attend your annual general meeting. And third is every director of the company will also get the notice. It's a meeting of the shareholders. Members are receiving their legal representative or insolvency में assignee को. Every director will also be given the notice. So members, auditors, and the directors will be given the notice. Clear? Any accidental omission to give the notice or non-receipt of such notice by any person who was entitled to receive the notice shall not invalidate the proceedings of the meeting. अब अचानक से हमने इलेक्ट्रॉनिक मोड से मींस ईमेल से नोटिस भेजा और एक मेंबर जो था कंपनी का, one of the member, he did not get the notice. He did not receive the notice. Why? Because his Gmail was full. He could not get the notice. So now will the meeting get invalidated? The answer is no. In case of accidental omission means by mistake somebody has not received or he has not got the notice because his email is full or any other reason, this will not invalidate the meeting. The meeting still will be conducted and will be a valid. Now under section 101 of the Companies Act, provisions are given for the notice, but rule 18 talks about sending the notice through electronic mode. So if examiner gives you a straightforward questions for electronic mode, you will have to write all these 5-6 points and I'm going to discuss with you. So he will ask you, can we send the notice through electronic modes? Yes, ma'am, sending the electronic mode is statutorily recognized. मतलब ये हमने नहीं बनाया है, ये लॉ में कहा गया है कि आप व्हाट्सएप, जीमेल, फेसबुक इस पे इलेक्ट्रॉनिक मोड से मेल्स के थ्रू आप नोटिस भेज सकते हो. What is the meaning of electronic mode? Any communication sent by the company through its authorized and secured computer program. Means if the company is having their company logo, Reliance वाले अपने Reliance email ID से भेज रहे हैं, which is capable of producing confirmation record of the communication addressed to the person entitled to receive at the last electronic email address. So whatever email address that member has provided, say for example, you are a company Reliance. So Ambani ji or somebody is sending the notice for your AGM. So xyz@reliance.com, whatever is the email ID or logo that they're using, they will send it to Mr. A @so-and-so gmail.com, whatever the email ID you have provided to the company. So the communication will be made at the email ID that you have provided to the company, plus it will be made through a secured computer program, which the company has been using. Clear? Okay, first 2 points. Number 1, the notice can be sent. It is statutorily recognized. Number 2, it has to be sent through a secured computer program at the email address provided by the member. Notice may be sent through email as a text. You can type a text. You can even send as an attachment. Attachment कर सकते हो. नोटिफिकेशन थ्रू इलेक्ट्रॉनिक लिंक, कोई लिंक क्रिएट कर आप भेज सकते हो. यूनिफॉर्म रिसोर्स लोकेटर फॉर एक्सेसिंग सच नोटिस. Nowadays you send the information through drive. Have you seen when there's so many Google photographs, if you attend any event, so it is not necessary that we send all the attachments for the photographs. We use that Google Drive link. So you can open it, you can access the videos or photographs by clicking on that link. So similarly, उसने आपको options दिए कि notice आप text में send कर लो, attachment में send कर लो, electronic link दे दो, या फिर uniform resource locator भी दे सकते हो. You have to learn these words. MCQ में he can ask you, can we send the notice through uniform resource locator for accessing the notice? The answer is yes. It is one of the means of sending the notice through electronic means. Email shall be addressed to the person entitled as per the records of depository. So where will you find the emails? ये Mr. A की जो मैंने कहा था a@gmail.com, ये email कहाँ दी होगी? Records of the depository, register of members, depositories, online form, demat forms. You are a member now. Records of depository में आपका नाम आ गया. Remember, we have discussed all this. So once your name is there in the records of the depository, whatever email address has been given over there, at that email ID, you will get the email. Company shall provide advance opportunity at least once in financial year to register their email addresses and changes, and such request can be made by members who have not got their email recorded or update a fresh email ID. So company should give them an opportunity कि अगर आपको अपना email ID change करना है, अब किसी का email ID बहुत full हो जाता है तो बार बार उनको वो error आता है. Have you seen this thing in your Gmails? Have you received such errors where they ask you that your storage has reached a limit, you cannot receive further emails? Then either you buy the storage or you try to create a new email ID. होता है ना? Good. No, Naina says no. Okay, so you're not using so common. Harshita, good. Storage is full. They ask you to get subscription. Yes, indeed. So what you can do is you can create a new email ID. Now, if you have created a new email ID, you will have to intimate the company because तभी company को पता लगेगा. तो company chance देगी कि अगर आपने change कराना है या new email ID बताना है, so you can let us know. All right, so these are your specific rules related to electronic mode. It is statutorily recognized. What is the meaning of electronic mode? लिख कर आओगे आप. Email can be sent as a text, attachment, or uniform resource. Email should be addressed as per the records of the depository, and opportunity shall be given to review. Is that clear? Subject line in the email shall state, then subject hota hai email mein. You will tell the name of the company, notice of the type, date and place. This shall also be written. You have to tell this thing in the subject of the email. Notice shall also be placed simultaneously on the website of the company and on the website as may be notified by CG. Okay, so this is also important. You cannot say that we have simply posted, we have written the notice on the email. First, the subject line that you have, it shall also indicate the date and place, and also it shall be updated on the website of the company. Just give me yes, so it shall also be placed on the website of the company. Now, this is very, very important. Where the notice is sent by post, it shall deem to be served at the expiry of 48 hours after the letter containing the same is posted. What does it mean? If I'm sending the notice by a post, all the points number 1 to 7 relate to email of the notice, electronic mode. Here I'm sending the notice through the post office. Okay, so I will be putting this in the post and the postman will come and deliver the notice. So law says whenever the notice is sent by post, it will be assumed, it will be deemed at the expiry of 48 hours after the letter containing the same is posted that the notice has been served. So if I have posted the letter on 1st October 2023, by when it shall be assumed that the notice has been served? Tell me immediately. 48 hours is 24 hours in one day. 48 hours, 2 days. So on the expiry of last, yes, 3rd October 2023, it will be assumed that the notice has been served on the expiry of 48 hours. So if I have sent this on 11 a.m. on 1st October, so at 11 a.m. on 3rd October, it will be considered as if the notice has been served. It shall deem to be served means मान लिया जाएगा 11 a.m. 3rd October तक कि आपको notice serve हो चुका है whenever it is sent by post. So what is the limit? 48 hours you have to remember when the notice is sent by post. Is that clear? Let us quickly open the study material and read all the provisions related to the notice of the meeting. Shalini, you want to ask something? You can type it in the chat box. We will talk once we are done with the slips. Okay. I hope we have done all these questions of EGM. So let us go back. I told you general meetings is given. Nidhi, you were asking 7.82 से शुरू होता है. General meetings and EGM, all these sections are given. Okay, Shalini, not a problem. And here we have where you finish about the registers. There we start about the meetings. Here is your section 101. ये proxies का है. We have all these sections of 101. So section 101 starts from here. Board meeting, class meeting हमने discuss कर लिया था. 21 clear days. Everyone is clear about this now. In section 8 companies, remember chapter 2 में आपने पढ़ा होगा या फिर आपने 1 chapter पे भी देखा है incorporation पढ़ते हुए. Section 8 companies. कौन सी थी section 8 companies? निधि, because उन्होंने पहले आपको requirements of a meeting दिया है, उसके बाद उन्होंने आपको types of meetings दिया. Okay. Priya Mishra, section 99 is given here only, bacha. After 97, 98 is given. There they have given. So it is again given after the AG. Okay. Section 8 companies, kaun si thi? Charitable organization, non-profit. Very good. All of you are correct. So what was the limit? If you remember, there were 5-6 significant points. Those you did in CA Foundation also when you learned it. So what was written over there? Instead of 21 days, 14 days notice will be served. Instead of 21 days, 14 days notice will be considered. Where did it go? Instead of 21 days, 14 days notice will be served in case of section 8 companies. Then we have discussed members, auditors, directors are the people to whom the notice has to be served. See how beautifully study has made a diagram for you. What is the meaning of 21 clear days? We have done. If the meeting is sent by post, what is the time period when it will be served? On the expiry of 48 hours. Then we have done all these. Notice will be sent as a text, attachment, uniform the source locator. This is important. इसको important mark कर लो. ऐसी चीजें आती हैं एग्जाम्स में, एमसीक्यू में आ जाती. सब्जेक्ट लाइन हमने पढ़ लिया. ये सारे पॉइंट्स हम अपनी प्रेजेंटेशन में कवर करते हैं. नॉन रिसीट ऑफ द नोटिस. According to section 101, any accidental omission, I told you, will not invalidate the meeting. The onus is on the company to prove that the omission was not deliberate. So company will have to tell them that ऐसा नहीं कि हमने जानबूझकर आपको नोटिस नहीं भेजा, हो सकता है कि रह गया या मिस्टेक हुई है, या accidental omission is very, very important. Right, Nidhi, you can say that. Mr. Abhinav, a member of Elixir Logistics Limited, filed a complaint against the company for not serving him notice. So I told you, if notice is not served, if there is an accidental omission, by mistake, you have accidental omission का मतलब लिख लो please सब लोग. By mistake, if company fails to give the notice, then it will not invalidate the meeting. Then it will not invalidate the meeting. So Abhinav was a member of company and he was filed a complaint because notice was not served to him for attending AG. Company provided the proof that they have sent the notice by way of email. Abhinav says that he never received it. Will the company be held liable for guilty of contravening the provisions of 101? Tell me in your own words, what should be the answer? What should be the correct answer to this question, illustration 4? Give me the reasons, what you think. Not invalidate का मतलब क्या है? प्रिया मिश्रा पूछ रही. Very nice. Good. At least you asked it. Not invalidate means, that means the meeting will not become invalid just because you were not invited. So let's assume, Priya, you are the member of Reliance. I am the person who is sending the notice. I have sent the notice to all the members, all the directors and auditors of the company, but I forgot to send you the notice. Now you got angry and you said, this meeting is not valid. You would not send the notice to me. How can you do that? I am a member of the company. You will file a case. Now company has to prove that it was by mistake that we did not send you the notice. Company will not be held liable. Not invalidate means ये नहीं है कि मीटिंग को वो कहेगा प्रिया मिश्रा बोलेगी मुझे नोटिस नहीं भेजा, ये मीटिंग वैलिड नहीं मानी जाएगी. तो वैलिड नहीं मानी जाएगी मींस इनवैलिडेट कर. हम उसे इनवैलिडेट नहीं कर रहे, तो दैट मींस नॉट इनवैलिड. क्लियर है बच्चा? ब्यूटीफुल आंसर्स गिवन बाय संगीतवनी, Ishan, Jandra, who else is given? Anandruti, very good. So you will have to prove this point that it was an accidental omission. Anushka, good. Company is not liable. So what we have to prove? Let's read what is written over here. It says Rule 18 tells you that it's the company's obligation to transmit the email. Company की obligation क्या है? Email कर देना. Company is not responsible for transmission beyond its control. Your Gmail is full. Your internet is not working. Internet not working. You are at a place where the net is not coming. So we are not responsible. How can I take responsibility of all the members that if I have to call them and ask them, look, have you received my email? Then why am I sending an email? Then I should have called them only. Na? So company says, we have sent the email. It's okay. Please relax. Check your storage box. It might be full. Or you have to prove. You have to give them the proof that company has sent the notice. Or if there is an accidental mistake, then company should not be at fault. Company is not responsible for failure in any transmission beyond its control means. अगर कोई network failure है तो company liable नहीं. If member fails to update his, हो सकता है member ने अपना email address ही नहीं update करा. I told you this point now. Member has not updated his email address. Then also it is member's fault. Company will not be at default. Accordingly, here the company is not guilty because there is no failure in this transmission is beyond its control or where Abhinav has not updated his email address. Everyone is clear on illustration 14? If you have not sent notice, and so Priyanshi, that you'll have to prove. If company is trying to cheat you, if company is trying to do something wrong, then company will be caught. Okay. Onus of proof is a legal word. ये जो लिखा है ना, onus is on the company to prove. So your law says that you have to prove it that it was not deliberate. You are writing in your query, ma'am, I did by mistake, I did it intentionally, then you will be held liable, you'll be caught. Okay, 101 पूरा कर फिर हम ब्रेक लेंगे, फटाफट से कंप्लीट कर. So when can I give a shorter notice? Whose consent is required? Less than 21 days notice in case of an AGM. Who will give the consent for shorter notice? Who has to give the consent for the shorter notice in case of AGM? At least 95% of the members who are entitled to vote. In case of EGM, company having share capital, majority of the number of members, and holding 95% of the paid up share capital, not having share capital, then it shall be 95% of the total voting power. Is that clear? Let's solve illustration 5. Everyone, you'll not read the answers. You'll just look here on the screen. Paid up share capital of the company is 50 lakh rupees divided into 5 lakh shares of rupees 10 each. Directors are going to call an EGM by giving a shorter notice. कर सकते हैं, अभी पढ़ा हमने, शॉर्टर नोटिस कर सकते हैं. पेड अप शेयर कैपिटल है तो क्या होगा, कितनी लिमिट होनी चाहिए? 50% ऑफ द मेंबर्स है, यस बोलेंगे, प्लस 95% ऑफ द शेयर होल्डिंग. दोनों प्रोविजंस देखनी है हमें in case of a company having share capital. 60% of the members holding 40 lakh shares have given their consent. Can EGM be validly called? Yes or no? Is it a valid notice? Yes or no? फटाफट से बता दो मुझे बिना आंसर चीट करे. Yes or no? Not a valid notice. Soumya, Ishan, Priya, Sunil, Kirti, Almas. One condition is satisfied. Good. Memory, Nidhi. Excellent. Very good. Naina, Sandeep. All of you, wonderful answers given by all of you. No is the correct answer because 60% तो है, but 40 lakh से at least 95% होना चाहिए. So answer भी पढ़ लेते हैं किस तरह से लिखना है. Consent to call EGM has to be given by 60%. 40 lakhs, which works out to be holding shares worth rupees 40 lakhs. So how many has been there? 50 lakhs. So 40 lakhs is only 80%. So 95% is the condition. So you will have to tell them shareholders holding at least 47 lakh 50,000 must have given their consent. बच्चा ये परसेंटेज एक बारी करके देख लेना, कई बारी हमारी तरफ से मिस्टेक भी हो सकती है. आनंद, रुति, ओमकार, शैलजा, good answers. Khushi, there are 2 Soumya in the class. Both of you have written correct. Sandeep, nice. Okay, clear? Then we have done EGM. Authority to call EGM is with board of directors. Can individual director call the general meeting? This is very interesting. ठीक है, illustration 5 सबको clear है ना? आगे चलते हैं. Authority to call general meeting. किसके पास authority है general meeting को call करने? It says AGM and EGM वैसे तो has to be called by board of directors. Can individual director has the authority? It says law says no. A single director cannot call the general meeting. Any notice given without the sanction of the board is invalid. However, the same can be rectified by the board. For calling a general meeting, board passes a board resolution. So यहाँ पे अपने notes में लिख लेना, a single director does not have the power to call AGM or EGM. So who has the power? Board has the power to call the AGM or EGM by passing a board resolution. Is that clear? Let's solve one question also from We have done annual return also, section 92. Yes. We'll do one question and then I will give you a break, okay? Onus means proof. Yes, beta, Omkar, onus का मतलब होता है proved in. Yes, yes, you need to cross check the percentage also. निधि कह रही है एक बार illustration 5. निधि क्या नहीं समझ आया बेटा illustration 5 में? You can ask me, okay? Please read this question and I want you all to solve it. Madurai Limited issued a notice for holding AGM on 7th November. Notice was posted on 16th October. Some members said that the company has not complied with the provisions. Meeting was valid, referring to the provisions whether the meeting has been validly called. If there was shortfall, please tell how many days shortfall. Can the company delay in giving the notice can be condoned? Okay, condonation of delay, we have not discussed this point. Okay, don't leave the third point. Best Limited has decided to conduct its AGM on 28th September. They have sent the notice on 9th September for which they have taken the consent of 90%. दोनों में आपने मुझे बताना है क्वेश्चन 6 में जो चॉइस दिया है. In both the cases, you have to tell me, is there any shortfall of the notice and what should have been done? Take 2 minutes, solve it. What is the correct answer? How many days notice? Starting from 7th, 16th October till 7th November. Will you count the date 16th and 7th? No, ma'am. And if you count the days starting from 17, 18 up till 6, how many does it turn up? 21 clear days. Excellent. Very good. 18 days fall down. Why, Nidhi? It is total 21 clear days. Absolutely. Julie Kumari, Ishan, Priyanshi. It's more than 21 days. It's exact 21 days. It's okay. No shortfall, Ishan, correct. Priya, correct. Harshada, Sandeep, absolutely correct. Everyone, 21 days. In the second case पे भी आते हैं, रुको जरा. 21 days सबको clear हो गया ना? मैमिदी सेती, अनुष्का, खुशी, आनंद, रुथि, सबने ठीक आंसर दिया. So 21 clear days. Now it says if there is a shorter notice. So here what is happening? 28 September and 9 September. यहाँ पे है valid days. Have you counted for the second one also? Yes, tell me for this one also. Best Limited के case में. Very good. Priyanshi, Kirti, Naina. It is less than 21 days. Very nice. The delay in proper giving because the consent should have been obtained. Very good, Sandeep. So absolutely correct. In the second case, it is less than 21 days. So the consent should be taken from 95% of the members. Now my question to the class is, do I need to take the consent of more than 50% of the members also over here? Why only 95% of the share capital? Why no? Why? Very good, excellent. Because it's AGM. अरे भाई याद भी हो गया. वो तो मैम ईजीएम के केस में है 2 कंडीशंस, एजीएम में तो कोई कंडीशन नहीं. So you will write down section 101 gives you that the general meeting can be called by giving 21 clear days notice. 21 days with 2 days have to be excluded. In the given question, 21 days have to be given. So he has taken the question for best limited. 19 clear days notice, therefore the meeting is not validly called. It falls short by 2 days. Companies Act has not specified anything relating to the condonation of delay in giving the notice. Hence, the meeting cannot be condoned. So you cannot say because of the delay, we want to cancel the meeting. Nothing relating to this point has been given on the Companies Act. It will not be valid meeting if you have delayed the notice. All right, so let's take a small break here and then we will be starting from section 102 after the break. So we're taking a break here. Welcome back to the class, students. Let's proceed ahead with section number 102. So what is section 102 going to tell you? We have already sent the notice to the members and now we are going to share the explanatory statement. So I told you there are two types of business to be transacted. If I am going to do a business of declaring a dividend, then it's an ordinary business or special business. Tell me. I hope you all are back from the break, children. So if I am doing a declaration of dividend, what kind of business I am transacting? It's an ordinary business or it's a special business? It's a ordinary business. Excellent. All of you are correct. If I am appointing the auditors and fixing their remuneration, it's an ordinary business or special business? Very good. Excellent. The students on the portal also, good answers given by all of you. Nice. So what is a special business? Anything which is not an ordinary business, any business that we have transacted, which is not. So four types of ordinary business we have discussed: considering the financial statements and reports of directors and auditors, declaring of dividend, appointment of directors in place of those retiring, appointment and fixing of the remuneration of the auditors. All these are the ordinary business. Any business we are doing apart from these will be considered as a special business. Now I told you all the business of AGM are special business because generally the business for AGM is all business shall deem to be the special except the one stated above. So these are the ordinary business. We can have special business in AGM also, but in EGM, we always transact a special business. Like for example, if I am going to do a business for new investment, we are going to buy a new building for our office, then what kind of business is this? It is a special business. It is not an ordinary business. It's a major investment. Or we are planning to change the business, change the line of business. So we need to meet to transact. What business are we going to start? What new business are we going to start? It is a special business. So for this special business, we will always hold an EGM. Now, special business to be transacted at the company's general meeting, a special notice has to be sent along with the notice for the meeting. So whenever you are doing any special business, so for explanatory statement, you have to understand two types of business. एक होता है ordinary business, जिसमें हम चार transactions करते हैं. AGM is generally for the ordinary business. And EGM में क्या होता है? Special business या ordinary business? जल्दी बताओ. EGM में special business. Very good. So जब भी हम special business करते हैं, उसके लिए हम notice के साथ एक explanatory statement send करते हैं. क्या स्टेटमेंट है? एक्सप्लेनेशन देनी पड़ेगी ना. अब हम इतना बड़ा डिसीजन ले रहे हैं, टेकिंग अ न्यू बिल्डिंग फॉर द बिजनेस, और वी आर ट्राइंग टू चेंज द business what we have been doing. So we need to send the explanatory statement. This statement will specify the nature and concern of financial interest, what kind of transaction we are going to do. Okay. It will also specify every director and the manager, any other key managerial or his relatives, or any other facts and information that will help the members to understand the type of business that we are doing and taking a decision. So what kind of financial interest if members, directors, KMPs and their relatives are having? Say, for example, the building that we are going to purchase, say, for example, our business is in Delhi and we are trying to purchase a new building office in Rajouri Garden, which is in Delhi. It's in West Delhi. So now this building that we are purchasing, it belongs to Mrs. A. Mrs. A is wife of director of the company, Mr. A. So Mr. A is company's director and his wife, Mrs. A, is owning this building. So now if you are trying to purchase this building as a company, you have to disclose the interest of the relative of the director. So you have to specify this line because somebody who is related to the company is holding financial interest in this property. So all these facts and decisions are very important to be disclosed so that the members can take their decision in a proper way. वो फैसला कर सके कि हमें यहाँ पे invest करना है या नहीं करना. So what does the explanatory statement has to tell you? Number one, the nature and concern of financial or otherwise interest held by director, manager, KMP or their relatives, or any other information that the members should be knowing, which will help them to take the better decision. Now, if you don't disclose this or you give insufficient disclosure, then what will happen? So section 102 clause 4 says, if you have not disclosed or you have given the insufficient disclosure, then any benefit that the promoter, director, manager or KMP will get, they will hold this benefit as a trust for the company and they will have to compensate to the company for whatever benefits they have received. Say, for example, promoter gets a benefit of 1 crore rupees after the director, Mr. A, gets a benefit of 1 crore rupees when the company purchased this building. So now, if they fail to tell that this building belonged to Mrs. A, that means they have made non-disclosure, they have not made proper disclosure. Now, this 1 crore rupees as a benefit that director or promoter has received, he is holding this money as a trust for the company. He will have to compensate to the company for this benefit. Means उसे pay back करना पड़ेगा. In short, he will have to return or pay back this money. He will have to compensate this money or benefit to the company. Clear ho gaya? Provided where any special business affects other company, extent of shareholding in that company shall be disclosed. So whatever kind of business you are affecting the another company, whatever shareholding that you have with another company, that will also be disclosed. If the extent of shareholding is 2% or more of the paid up share capital of that company. So there is a company A Limited. If you are investing in B Limited and the director of A Limited, Mr. M, is holding more than 2% of the share capital of B Limited. So if you are holding more than 2% of the paid up share capital of that other company, then you will have to disclose this interest also. Any business item document which is to be considered at the time and place document should be inspected. So you can also keep this notice and explanatory statement shall be kept open for inspection also. Anyone can come and inspect these documents. And if you don't follow section 102, you contravene the provisions, means you're having the interest, you're not disclosing. You're holding more than 2% of the shareholding, you're not disclosing. You're having your promoter, director or KMP is having a shareholder. Here he is not talking about the relative. Please mark it. Here he's not talking about the relative. In the first provision, he's talking about the relative. In the second provision, he is not talking about the relative. Don't worry, Dhanush. We will read line to line from study material also. Dhanush, section 102 clause 4. Section 102 clause 4 tells you that if you have received any benefit, means अगर आपको फायदा हुआ है, आपने नहीं बताया कि वो बिल्डिंग डायरेक्टर की वाइफ की है, कंपनी ने वो डायरेक्टर से खरीदी. So now whatever benefit that the company has get out of it, company will give it back to the director will give it back to the Is that clear, Dhanush? No, Harshita, it's not a public document. This is the document which we are sending to our members, like along with the notice, this statement is going. Now, if you contravene, every director, manager, or key managerial personnel who is in default will be liable to a fine of 50,000 or 5 times the amount of benefit accruing to the promoter, director, personnel, or his relative, whichever is higher. So, हमारे केस में कितना benefit में दे रही थी 1 crore का. So 5 times of 1 crore is 5 crores. Oh my God. Or 50,000, whichever is higher. तो कितनी penalty देनी पड़ेगी उसको? 5 crores. Okay. So you have to tell if you have any business. Is not required for transacting ordinary business. Please note that you don't need to send any kind of explanatory statement for transacting ordinary business, क्योंकि ordinary business पे तो हम ऐसा कोई interest है ही नहीं है. उसमें तो हम सिर्फ अपॉइंटमेंट ऑफ डायरेक्टर्स, अपॉइंटमेंट ऑफ ऑडिटर्स, डिविडेंड डिक्लेरेशन ऐसी बातें कर रहे हैं. उसमें कोई भी एक्सप्लेनेटरी स्टेटमेंट देने की जरूरत नहीं है. सिर्फ स्पेशल बिजनेस में एक्सप्लेनेटरी स्टेटमेंट की रिक्वायरमेंट है. Is that clear? Now you want to see the explanatory statement first from the module. So explanatory statement has to be given when special business is done. Every nature or interest of director relatives has to be disclosed. What is ordinary? What is special business? We have just done. This is a beautiful picture of ordinary business. You will have to learn it. As it is, 2 marks, 3 marks question can come in the exam. What are the 4 types of ordinary business? You will write it straightforward. In AGM, all the business has to be transacted except the one stated as special business. At AGM, we always do special business. If any item relates to the or affects the other company, the shareholding in which is more than 2%, you will have to disclose it. Okay. So non-disclosure, I just told you that you're holding as a trust for the company and you will have to give it back. So it is the same provisions that we have just read. So since they have not given you the question, so let me give you a question from 102. So do you enjoy doing the question also related to the topic? Somehow I have also got into this habit with all of you now that we should do the concept and then try to figure out what is the question related to that concept. So 102 is now clear to my students. Let's try to understand one very, very simple question. OM Limited served the notice of general meeting upon its members. The notice said following resolutions will be considered. Resolution to increase the authorized share capital of the company. Appointment and fixing of the remuneration of Pratik as the auditor. A shareholder complained that the proposed increase in remuneration was not specified in the notice. Is it a valid notice? So what is happening? 2 matters are to be discussed. Which is a special business and which is an ordinary business? Can you tell me in the chat box? So the first one is the special business to be transacted and the second one is the ordinary business. Now it says in case of any meeting other than AGM, all the business that has to be shall deemed to be the special business. For any special business, explanatory statement has to be given. You will disclose the nature of interest, any interest held by director, KMPs, and also any other information fact has to be disclosed. As it is, जो मैंने अभी आपको पढ़ाया section 102 subsection 1 में, you will write it down that you will have to disclose. It becomes compulsory. Explanatory statement have to be given. The information about the amount is also a material fact. Members want to understand the implication of items. So वो कहते हैं amount नहीं आपने बताया, भी कितना increase करेंगे. So that is also a matter of concern which they are requesting to know. Part section 102 also tells about the ordinary business for which there is no need of explanation. So part 1 of the question falls under special business, hence the absence of the amount notice will become invalid. Part 2 is ordinary business. No explanatory statement is required. So considering the 2 resolutions, the notice of the meeting is invalid. Objection raised by the shareholders is valid. because the detail on the items are to be considered as whole. Is that clear? So have you understood? So if this kind of questions come, you will be able to express your opinion, or you will be able to write your viewpoints only if you have learned the content very well. If I have not learned it, I have just gone through the pages, ma'am ने पढ़ाया था, मुझे समझ आ गया, but मैंने revise नहीं करा, then my dear students, it becomes very difficult for you to express your viewpoints on this. For expressing your viewpoints, you will have to learn. Now comes a very interesting section, section 103, जिसके ऊपर हम बहुत सारे questions भी करेंगे. What is the meaning of quorum for the meeting? So we are done 101, 102, notice, explanatory statement, it is absolutely clear, types of businesses also done. Now we are doing quorum. So in case of a public quorum, it is different. In case of a private company, it is different. So quorum means for how many members will be personally present for conducting a meeting. Unless the articles provide for a larger number, means अगर तो articles में कहा है larger number, then you will follow articles of association. पहली line बहुत important. If my article says that the quorum should be 100, then you have to follow that. If my article says my quorum should be 45, you have to follow. Unless the articles provide for a larger number, means larger provide कर सकता है, smaller provide नहीं करेगा. Articles can provide for a larger number of quorum. लिखो, अपने हाथ से लिखो इसके साथ. Articles of association of a company may provide for a larger number of quorum. Quorum means number of members who shall be personally present for the meeting. Quorum means number of members who shall be personally present for the meeting. Clear? So now what is the quorum for a public company? So it depends upon the number of members the companies have. If the number of members are not more than 1,000, means up till 1,000. Not more than 1,000 means less than or equal to 1,000. Not more than 1,000 means less than or equal to 1,000. Then 5 members personally present. If my number of members are more than 1,000, but it is up till 5,000 number of members, then my quorum will be 15 members. And if I have the company which is having more than 5,000 members, like Reliance, Tata, badi companies, unka quorum kitna aega? 30 members personally present. Now, this is the provision in case of a public company. Private company always keeps it simple. 2 members personally present. बस दिक्कत ही नहीं. 2 directors, 2 members, सब कुछ 2 में ही चलता है उनका. Yes, Rajveer, personally means physical. No, larger does not mean maximum Priyanshi. Larger means कितना भी number provide कर सकता है ज़्यादा. Yes, Priya, it includes the members, including them. So 5 members for 1,000, 1,000 to 3,015, and more than 5,030. So if there is a company ABC Limited, having 3,000 members, what shall be the quorum for the company? What shall be the quorum for the company? All right, it is less than or equal to 1,000, so please. It's not more than, it's less than or equal to. ठीक है, 15 is the correct answer. So if the number of members are 1000, are you sure? If the number of members are 1000, very good. Julie, Anandruti, Shailaja, Kushi, Kamya, Ishan, excellent. 5 members is the correct answer. Yes, Rohit, you can write down your query in the chat box, bacha. Yes, Rohit, you want to ask something? All right. If it is a company, PQR Private Limited, having 300 members. पहली बात तो प्राइवेट लिमिटेड कंपनी है, 300 क्यों ले रही है, 200 members. Then the quorum will be 2 members. Private company में there is no limit on the number of members to be seen for quorum. 2 members personally present. Can the articles of association provide that the quorum should be 3 for a public company or 4? No, ma'am. It can always provide for the larger quorum. Now let's read about another important line, adjournment of meeting. So point number 1 was the quorum for the meeting. Easy है, public company, private company learn करना पड़ेगा बेटा 5, 15, 30 को. 1000 तक 5 है, 1 to 5, 15 है, more than 5 में 30. Adjournment का मतलब क्या होता है? Can anyone tell me what is the meaning of adjournment? Priya Mishra, where is it written for the articles in private company? It is only written for the public company. Okay, it's nowhere written for the private company. पोस्टपोन कर देना, वेरी गुड. मतलब हमने आगे कर दिया, किसी चीज को हम नेक्स्ट टाइम करेंगे, बाद में करना. वेरी गुड. टू गिव इट अनदर टाइम. एक्सीलेंट. कैंसिल नहीं होते, पोस्टपोन होते. ओके, वेरी गुड. सो एडजर्नमेंट फॉर द वांट ऑफ quorum. Now, what is the time period given for the quorum to be present? The quorum should be present within half an hour from the time appointed for the meeting. So, if I have given a time for the meeting, 11:30 a.m. and the number of members of the company is 900, then what should be the quorum and by what time the members should be present? How many number of members should be present by what time? Why are you writing 11? क्या लिखा है उसने? Within half an hour from the time appointed for holding the meeting. तो half an hour means 11:30 टाइम है, तो half an hour 12 noon तक हो जाएंगे, तो 12 बजे तक 5 मेंबर्स प्रेजेंट हो जाने चाहिए. ठीक है, क्लियर सबको? If only 3 members came till 12 o'clock, what will you do? You will have to adjourn the meeting to the same day in the next week at the same time and same place as the board may decide. So what will you do if members are not present by 12 noon? In my example, I've taken 11:30 a.m. So within half an hour, if the quorum is not present, full quorum 5 has to be present. If full quorum is not present, then the meeting stand adjourned. For example, this was held on Wednesday. So on the same day, Wednesday ko next week may at same time 11:30 a.m. and the same place, or board will decide any other date and time place, whatever the board will decide, or if nothing has been decided, the meeting will get adjourned to the same time and place in the next week. If this meeting was called by requisitionist under section 100, ये क्या होता है बेटा? मैं तो भूल गई, सेक्शन 100 में क्या था? कुछ हमने पढ़ा है सेक्शन 100? What is the name of section 100? Quickly tell me, hurry up. Section 100 tells us about EGM. What happened to my mouse? Who was a requisitionist in EGM? Company having share capital, company not having share capital. How many members were calling for the meeting? How many members are requesting the board? 1/10 of the board was requesting. क्या लिखते जाओ? 95%. Wow, संगीत बनी. 95% नोटिस में है अंडर सेक्शन 101. हाईलाइट करना है आज प्रोविजंस. सेक्शन 100, 110, section 101, 95% plus 50 members in case of a shorter notice. It's okay. You don't need to be sorry. It's good. You make mistakes here so that you don't make mistakes in your final exams. Okay. And wonderful answers given by all of you. And you have written the division also. Very well done. Now you all remember section 100, requisitionists have called the meeting. Now if the members are not present. So now you members are only requesting and calling, please come and let's hold a meeting. And you only did not turn up. Please cancel this meeting. Isko koi adjourn nahi karna. One member is calling another member for the meeting, 1/10 of the paid up share capital you're holding, and you're asking your members to come, and they're not even turning up. Cancel this meeting. It's not adjourned. So if requisitionists have called the meeting, quorum has not come, we cancel the meeting. If any other meeting, quorum is not present, we adjourn the meeting to the same day and time next week, or board will decide the time and place. छोटी सी slide है, but too much of information. So keep understanding, keep absorbing all the information. Clear? In case on the adjourned meeting, now requisition वाली तो नहीं होगी, cancel हो जाएगी, कोई और meeting adjourn हुई. अब adjourned meeting में या फिर change of date and time place में company will not give less than 3 days notice to the members individually or publishing in the newspaper which is in circulation of the place where the RO office is situated. So for the adjourned meeting, the notice period shall not be less than 3 years. Company will not give it. So minimum 3 days notice has to be given to the members that we have adjourned the meeting. Now the funny thing happens if the quorum is not present at the adjourned meeting also. वेडनेसडे को 11:30 मीटिंग रखवाई थी, हमने क्या करी, मीटिंग एडजर्न कर दी नेक्स्ट वेडनेसडे 11:30 और व्हाटएवर टाइम प्लेस यू हैव डिसाइडेड, 3 days का नोटिस दिया and meeting adjourned. Now you're still not present at the adjournment. Where the quorum is not present within half an hour, then whosoever members have come, please do the meeting. We can't keep on adjourning it. So 3 members came, meeting कर लें. Do we need to wait for 5 members if the number of members are 900? No. In the adjourned meeting, you will know. First, you will wait, adjourn the meeting. On the adjourned meeting, half an hour time, members did not come. जितने members आए, meeting कर. अब यहाँ पे बहुत इंटरेस्टिंग बात है. एक ही member आया. मीटिंग कर लूं? प्रांशी तक वेट फर्स्ट लेट्स कंप्लीट. एक्सेप्शन सारी इसी में आ जाएंगे. एक ही मेंबर आया, मास्किंग, मीटिंग कर लूं? सिंगल मेंबर हैज टर्न. वेरी गुड मेमोरी, Jandra, excellent. When I started today's topic, so I made you write one line. There are only 2 sections where a single person present, personally or as a proxy, can be considered as core. Jandra, a little bit wrong in writing the sections. Who is going to give me the section? Dhanush, little bit wrong. Anushka, excellent. Miss P, excellent. Soumya, Almas. क्या था अभी 97, 98 मुझे बता भी दो. मीटिंग हेल्ड बाय दी कीर्ति, वेरी गुड. अलमास, मीटिंग हेल्ड बाय ट्राइब्यूनल. Students, sometimes I feel so happy when you give me such a wonderful answer. It takes time to understand and absorb information. Even when I was a student, I was learning, I used to make notes, I used to use highlighters, and these kind of small points, if you just write next to the sections, you'll never forget it. And I feel so happy when you answer me so nicely. So one small request I want to make you, please go with the same flow in your exams also. Don't answer me here just to impress your teacher that, yes, ma'am, I know everything. I am very impressed from my students. I feel so happy that you all are responding back so nicely. But my humble request, learn it and do write these kind of answers in exam also. ऐसे क्वेश्चन पूछे जाएंगे. I'm so surprised everyone remembered and they have answered it correctly. Thank you so much. Thank you, Soumya. I'm so happy to read that. I'm glad you enjoy my teaching and you're absorbing this information. So the cherry on the cake is that you are reverting and you're writing back. So I'm really enjoying that. So children, please remember wherever sections जहां पे आपने ये लिखा है quorum section 103, write it over there. One member only in case of 97-98. Where you have written 97-98, there also write down only exception in case of tribunal. When you try to relate these points, you'll never forget. All right? Good. Well done. I'm so happy for all of you. Beautiful answer given by each and every one in the class. So quorum is not present in half an hour. One member is only in case of exception of 97-98. Otherwise, whosoever members are present will be treated as quorum. AOA can provide a larger number of quorum, not less than given in the Act. This we have already done. Can AOA tell you for having 4 members as the quorum? Yes or no? Very good. Correct. In case the person representing a body corporate, the shareholder is present in the meeting, he shall be considered as personally present. Now, in some cases, a company is a member of a company. I told you, a company is an artificial legal person. It can also become a member of another company. So there is a company, ABC Limited. It is a member in Tata Motors. Now, Tata Motors is holding its AGM. So ABC Limited has sent his director, Mr. A, to be present as the member of the company. So this Mr. A will be counted as the representative of ABC Limited. He will be counted as personally present. One member isko count kar liya jaye. But if Mr. A is a director of ABC Limited and also he is a member of PQR Limited. He is a shareholder member in PQR Limited also and he is a member of ABC Limited. Now, if he is representing 2 companies, then Mr. A will be counted as 2 persons for the quorum of Tata Motors AG. So if I'm one company, I'm sending my one representative, he will be counted as 1 member. If I am a representative of 2 companies, then I will be counted as 2 members. Clear? Then he will be counted as 2 members. Where a single person is present in a company having less than 1,000 members, can he be counted as quorum? No. The answer is no. 1 person is still required because minimum 2 persons will constitute quorum. You have already done this point. The exception is given under section 97 and 90. Presence of single member can never be called as meeting, even if the meeting is adjourned. Single member is not a quorum. Proxies will not be included in the quorum. Section 105 में पढ़ेंगे who is a proxy. But अभी क्या बता रहा है? Proxy is never counted for the purpose of quorum. So quorum में कौन count होंगे? Shareholders, members. Suppose 5 होने चाहिए. 3 shareholders have come. They will be counted as 3 members. 1 company has sent his 1 representative. He will be counted as 1 member. 1 proxy has joined. Should I count him as the member? No, he will not be counted. And then 2 companies, 2 companies have sent 1 person. He will be counted as 2 members. So there are total 6. We can hold a valid meeting. Quorum is said to be present. Clear है? करें क्वेश्चन सॉल्व फटाफट से quorum के. Public company, quorum given. Private company, 2 members personally present. Adjournment हो सकती है. What is the time limit for the quorum to be present? What is the time limit for the quorum to be present? Half an hour from the time scheduled for the meeting. If it is not present, then what happens? Meeting stands adjourned. If at the adjourned meeting also quorum is not present, If at the adjourned meeting also quorum is not present, what will you do? Meeting continues with the number of members who have come will form the quorum. Very good. Now this point is very, very interesting. In fact, I find it little hilarious also. One person can be authorized representative of more than one body corporate. He will be treated as more than one member. मैंने अभी बताया आपको, Mr. A, who was the representative of ABC Limited, and he was the representative of PQR Limited. So children, we will be counting Mr. A as how many members? 2 members. Why? Because he is representing 2 companies. सबको clear है ये point? However, at least 2 individuals should be present in a meeting. Now, what happened? There was a company. They said there was Mr. A who was representing 5 such companies. He was the representative of 5 companies. Now, you will be counting him for how many number of members? इसको कितने बंदे के लिए count करा जाएगा? 5? Good. सबने आंसर कर दिया. He will be counted as 5. Now, only Mr. A turned up for the meeting. मीटिंग कर ले, कोरम हो गया पूरा. क्या कहते हो? कहते कम से कम एक इंडिविजुअल तो और होना चाहिए भाई मीटिंग करने के लिए. ये थोड़ी ना कि अगर सिंगल पर्सन 5 कंपनीज रिप्रेजेंट कर रहा है तो वो अकेला आकर मीटिंग करके चला जाएगा. दिस इज नॉट पॉसिबल. Sounds funny? So he says that single person cannot, at least 2 individuals shall be present. If public company having less than 1,000 members, it requires 5 members. Any representative of 5 bodies will not form a quorum by himself, but he can do at least 1 member. अगर Mr. B भी आ गया साहब, तो फिर भाई सही है, 5 + 1 6 members हो गए. अब आप मीटिंग कर सकते हो. Clear? Quorum should be present not only at the commencement but also while transacting business. 5 members आने थे. They started 11:30 मीटिंग स्टार्ट करी. मीटिंग चल रही है 6 बजे तक शाम को. 3 members गायब हो गए. Quorum will not go below 5 at any time. You have to be present for the whole of the time when the meeting continues. हर्षदा प्रॉक्सी के बारे में 105 में पढ़ेंगे. Now let's do this. Members have voted by remote e-voting have the right to attend and can show their presence will be counted. So if you have done e-voting also, then also if you turn up, you will be counted in the quorum. A member who is not entitled to vote, being a related party, if he is present, he will be counted for the purpose of quorum. Stipulation regarding presence of quorum will not apply for the postal ballot. तो ये e-voting postal ballot ये हमने अभी करा नहीं है. वोटिंग में 106 to 1010 में जब करेंगे तब समझ आए. अब illustration 6 है. There are 54 members in private limited company. Company called its AGM on 1st July at 2 p.m. at its registered office. There were 28 members present till 2:30 p.m. Chairman proceeded to start the meeting and pass the resolutions. Has the meeting taken place properly? Yes or no? There were 28 members present till 2:30 p.m. at the venue of the AGM. कितने members आने चाहिए थे children? Harshada, 54. 2 members should have been personally present. Yes, good. Why are you saying 5? Who's saying 5? It's a private company, Priya. 2 members should have been present. For the provisions, the quorum for the meeting shall be 2 members within half an hour appointed. The quorum for the AGM was complied and all the provisions have been followed. So it was just simply to confuse you, right? Everybody understood? Yes, Nidhi, message me in the chat box. क्या नहीं समझ आया? क्या नहीं समझ आया बेटा? Stipulation कहाँ पे पढ़ा आपने? Stipulation होता है condition. Condition regarding the quorum will not apply for the postal ballot. मैंने अभी बताया आपको postal ballot और e-voting जब हम करेंगे voting के बारे में तब समझेंगे. Okay? Stipulation का मतलब होता है condition. Yes, Anushka, here the 28 are present, so कोई बात ही नहीं है problem. So there was nothing in illustration 6, just to give you a clarity that sometimes a detailed question is given, but there is nothing in that. So you have to simply write 2 members personally present within a half an hour. They should be in the meeting till the time the meeting continues. Illustration 7 देखते हैं. अबे Lights and Sounds has 2300 members. Limited company है. कितना quorum चाहिए? जल्दी 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 बिना चीटिंग करे. 15. Good. Company calls its AGM on Tuesday, 23rd August at 10:30 a.m. at the office situated in Connaught Place, New Delhi. On the date of the meeting, 18 members are personally present by 11 a.m. यहां तक मुझे बताओ कंडीशन सेटिस्फाई हुई कि नहीं. प्लीज मुझे बताइए यहां तक सिर्फ कंडीशन सेटिस्फाई हुई कि नहीं. Yes, ma'am, 15 were required to deal with this. Chairman came and started the meeting. There were 5 special business to be discussed, and by 2:30 p.m. Agenda 1 to 3 has been discussed and the resolutions were passed. अब ये चेयरमैन रेजोल्यूशंस ये अभी हम पढ़ेंगे इसके बारे में. जनरल मैंने आपको बताया था क्या होता है. मीटिंग हो रही है, डिसीजंस लेने हैं, चेयरमैन एक हेड है, लीडर है, वो आ जाता है, मीटिंग स्टार्ट करता है और हम डिसीजंस पास कर लेते हैं. Due to emergency, 4 of the members had to leave around 3 p.m. Chairman granted them the permission and proceeded with agenda 4 and 5. Resolutions were passed with the consent of remaining members. क्या यहाँ पे कुछ गड़बड़ हुई है? Yes or no? क्या यहाँ पे कुछ गड़बड़ हुई है? Is there any problem in the meeting? It says, has the meeting properly convened? Quorum shall not be present only at the time of commencement. It also has to be there for transacting all of the business. Members, at least 15, should have stayed. The requirement was that the meeting started. Quorum was not present for deciding agenda 4 and 5. Number of members is less than quorum. Therefore, the business cannot be transacted and shall be nullity, means null and void हो जाएगा. इसको हम नहीं मानेंगे. क्यों नहीं मान रहे हम children? Why we are not accepting it? Because the quorum has to be present for the full time of the meeting. Clear है? Clear है सबको? Meeting is not. अब फटाफट से चेयरमैन करते हैं, फिर क्वेश्चंस करेंगे. Who is the chairman? Chairman is the head of the meeting. Like I told you, when you're holding a function, you will send the notice and then you will appoint a chairman. How do you appoint a chairman? By show of hands. हैंड रेज करे हमने क्लास लीडर के लिए. कौन कौन कहता है मिस्टर ए क्लास लीडर बने? 10 बच्चों ने हैंड रेज करे आउट ऑफ 20. सो फॉर मिस्टर बी 8 हैंड रेज. सो ए के लिए 10 हैंड रेज है. मैक्सिमम मेजॉरिटी विल विन. सो हाउ डू यू इलेक्ट द चेयरमैन? They will elect the chairman on a show of hands. You will elect who is going to be the chairman for the meeting. निधि क्या लिखा है आपने? SS2. What are you writing? Yes, Miss P. Yes, for agenda 4 and 5, it will become null meeting. Yes, yes, Ishan, absolutely, children. बाकी तो सारा मीटिंग उनके सामने ही हुई है ना, तो 3 एजेंडा में कोई प्रॉब्लम. First, the chairman will be elected by show of hands. Then the demand for poll. What is poll? Poll meeting means, again, you will be polling for the election of the chairman. If the chairman is demanded, if the poll is demanded for the chairman, chairman elected by show of hands will continue to be the chairman until any other person has been become the chairman by the result of. So a poll meeting करते हो, इसमें आप अपने नाम दोगे, result दोगे. How the poll has conducted? Section 106 to section 110 deals with all the voting provisions, voting by show of hands, voting by demand of poll, postal ballot. उसमें समझेंगे उसको कि पोल वोट से कैसे. बट अगर शो ऑफ हैंड से पसंद नहीं आ रहा है, पोल डिमांड कर रहे हो, तो तब तक जब तक पोलिंग का रिजल्ट नहीं निकलता है, he will be considered as the chairman. Powers of chairman. Chairman is the person who manages the meetings and maintain the decorum. He has the authority to decide all the questions for which the decision has to be taken. So the chairman is the major leader of your meeting. He will maintain the decorum, that proper silence is maintained. Nobody's talking, nobody's shouting, nobody's yelling in the meeting, nobody's fighting, and he will make sure that the proper decisions are taken. Chairman to have a casting vote if required. So casting means second vote. If, for example, a decision has to be taken whether we should open the office at ABC place or not. So the consensus could not be formed. They were equal yes, 5 says no. तो अब टाई हो गया, प्रॉपर डिसीजन नहीं लिया जा रहा. तो चेयरमैन के पास पावर होती है कास्टिंग वोट की. कास्टिंग वोट मीन सेकेंड वोट. तो चेयरमैन अब अपनी कास्टिंग वोट यूज करके ही कैन टेक अ डिसीजन whether that is ABC has to be used for the place of business or not. But this provision of casting vote should be given in the articles. Then only he can use this casting vote. In case of a private company, Section 104 shall apply unless there is specified articles provision. This exception will apply to a private company which has not defaulted in filing the financial statement. So, हम हर जगह पढ़ते ही रहते हैं. The company which is not defaulted in Section 137 and Section 92, they can get an exemption from appointing the chairman. Okay, so the provision of chairman is very, very simple. Section 104 is very simple. In fact, you could have done it by yourself only, but since we are doing it, chairman will be elected by show of hands. Demand for poll can be done. Meetings of the chairman power, he can have a casting vote. No question is given. Only exemption of private company is given. So now before we jump to proxies, I want you to do certain questions. Let me see the MCQs also. I'll give you 2 minutes, solve this MCQ and send me the answer. So very simple answer, 95% is the correct answer. So D, 95%. For the shorter notice, D would be the correct answer. I think this one we have already done. Let us do some important questions from Proxy. Not Proxy, Quorum. So एक Quorum का है, एक notice का है, दोनों करते हैं. First, solve this one. Kurt Limited is a company engaged in the business of manufacturing papers. Company has approached you to explain them the quorum for the meeting if the company has 800 members, quorum if the company has 6,500 members, quorum if the company has 5,500 members. The articles has provided the quorum for the meeting to be 50. So read the question very carefully. Okay, Kirti, when we open the module, I will explain you that point, okay? Good, Miss P. Somesh, John, Priya. निधि आप लिख रहे हो ए नो, मतलब अलमास गुड। ओमकार 65 कैसे हो गया बेटा? वेर यू एडिंग? Children, please read the full question and then send your answers. Articles as provide the quorum to be 50. What is that? Articles of association can provide for the larger quorum. Let's read the answer. Section 103 tells you that articles can provide for the larger number. In case of a public company, पहले आप लिखोगे provision. 5 members should be there if it is 1,000, 15 members and 30 members personally present if it is more than 5,000. If the company has 800, the quorum shall be 5 members personally present. If the company has 6,500, quorum will be 30 members. If the company has 5,500 members, it will be, since the articles has provided the quorum to be 50, the quorum shall be 50 members. Now, some of you have written that the quorum will be 50 for all of them. So here the hint was, how will you assume? We have taken the assumption that this is first part. So here the quorum is 800, so 5. This is second part, 6,500 to 30. This is third part, Almas and Miss P and Priya, those who have written for every case it is 50. No, it is only for C part. C part says 5,500 members, so it should be 30 or 50, whichever is higher. He has given for the higher, so 50 members will be considered as the quorum for the C. Is that clear? For the B part, Soumya, it is 30, not 50. For the B part, it will be 30 members. Is it clear, children, all of you? 5, 30, 50 is the correct answer. Jandra personally present means आप physically आए होने चाहिए. ये नहीं कि आपने proxy भेज दिया और आप नहीं आ रहे हो. So proxy will not be counted. You have to come and be present to be counted as the member for the quorum. Okay, try doing this one. P Limited has called AGM on 30th August. Mr. Pavan has filed a complaint against the company that he could attend the meeting as company did not serve. ये हम कर चुके हैं इससे related वैसे. Company provided the proof that they had sent the notice by an email inviting him to attend the AGM. Mr. Pavan alleged that he never received the email. So advice, the company has erred in serving the notice. What will be answer? Frame an answer and give me the answer for this. Frame it as proper case study. I give you 3 minutes for this. Solve it and write it in the chat box. Very nice answers given. Shalini, ये क्या लिखा है? Is only for the notification. Failure of transmission is not possible. Rajbir Ray, Priya Mishra. Good, Nidhi. Company is not responsible. That's correct. But I told you that you have to frame the answer. So very well answered, Sandeep, Soumya, Omkar, Mamid Sethi. Absolutely correct. Omkar, very nice. Kushi Mehra. So let me teach you once again. Sangeetwani, Nayana, Harshada, Priya Mishra, good. 30s in the second case. Okay, Miss P, I will explain you better. Memory, if not error. Jayendra, company is not responsible. Shailaja, very good. Okay. Miss P, I will explain you after this question, okay? So how you have to write here, you have to give Rule 18 provisions that the notice can be sent by electronic modes. Again, you will give all those points that by electron. See, children, if it is a 3 marks question, you will not simply write that, okay, company is not responsible. कुछ material तो दोगे ना उसको. मैंने आपको जब पढ़ाया था तो मैंने अभी क्या बोला था कि electronic mode से related if the question comes, write those 6 points. That you can send it as an attachment, as a notification, uniform resource locator, all these things. And also the company will have given an opportunity to update their email IDs. ये सब आपको पहले करके देना पड़ेगा. Why are you writing 101 Sneha Chawla? This is not related to 21 days notice, beta. This is related to electronic point. Company will provide opportunity to update your email IDs. Here the company has, as per the provisions of the Act, and keeping the above provisions in your mind, company's obligation will be satisfied if the company has transmitted the notice. It is not responsible for failure in transmission. If he fails to receive it and he has not updated his address, then it is the member's fault. Company is not in default in delivering the notice via email. Hence, the company has not committed any error in delivering the notice of AGM to Mr. Pawan. Company will not be held liable. Is that clear? So now somebody was asking a doubt over here. 800 members agar hote to beta the personally present quorum is 5. Then we did up till if your members are more than 5,000, then it is 30 members personally present. Here you will have 30 members. Miss P, क्या दिक्कत आ रही है यहाँ पे 30 members में? क्या doubt पूछ रहे थे आप? Yes, Neha, you have written email point, bacha, but you don't have to write 21 days notice. We're not asking you about that. We're asking you about e-notice, electronic mobile that I've just shown. Okay. Miss P, why do you want to take articles? I told you this is B part. Quorum if the company has 6,500 members. This is C part. Articles वाला जो point है वो C part में दिया गया है. इसमें और इसमें नहीं है. Where that question has asked. Okay, now understood? So read the question very carefully. अगर सब parts के लिए सारों के लिए होता फिर 50 was the correct answer. So it was only for the fourth part. Let's go back to the presentation. Okay, let's do one more interesting question from the Quorum. Beta, Rajveer, it will be written clearly. A part, B part, C part. Okay. So if you have this assumption, then you can take, we are assuming that it is for all the parts, you will get marks. But don't take a wrong assumption. A company, proxy we have not done. How can we solve proxy question? My mistake. Proxy नहीं करा ना हमने अभी. But quorum से related you और कर सकते हैं. Let's start with proxy then. We'll do proxy जितना हो गया ठीक है नहीं तो हम next class में carry forward करेंगे proxy को भी ठीक है. Any member who is entitled to attend and vote at the meeting shall be entitled to appoint another person as a proxy. So if I am a member of Reliance, Mr. A, I can appoint any proxy who can go and attend and vote at the meeting on my behalf. Proxy will not have the right to speak. He shall not be entitled to vote except on a poll meeting. So whenever the meeting happens by poll, then only proxy can participate. Otherwise, proxy does not have the right to vote by show of hands and does not have any right to speak at the meeting. So is it compulsory that only a member of the company can be appointed as a proxy? The answer is no. Any person can be appointed as a proxy. If I want to send my sister as a proxy on behalf of the company in which I'm a member, can I send her? Can I ask her, please go and attend the meeting on my behalf? I can't meet. ऐसा हो सकता है? I'm asking you. Tell me, is it possible? The answer is yes, I can send anyone, even the person is not a member, can be appointed as a proxy. But Section 8 company is the only exception which says that only a member can be appointed as a proxy. Okay. Unless the articles provide, this subsection shall not apply to a company not having share capital. So this is just an information. Central government may prescribe the class of companies who shall not be entitled to appoint another proxy. Okay, this is also an information. A person shall not act as a proxy on behalf of a member. This is important. So a person shall not act as a proxy on behalf of members exceeding 50 and having prescribed number of shares. So you can be a proxy for maximum 50 members. 50 members को present कर सकता है एक single proxy. So you can be a proxy for 50 members. Legal representative होना जरूरी नहीं है. Naina, no, it's not legal representative. It says any person can be appointed as a proxy. Only in Section 8 companies, the person who is appointed as a proxy should be a member of the company. In other companies, it is not necessary that the proxy should be member. This is the first point. Second point, we said that he does not have any right to vote and speak at the meeting. He will only vote in case of a poll meeting. Third point, proxy can be acting on behalf of maximum 50 members. 50 बंदों के behalf पे proxy act कर सकता है. Rule 19 tells you that the member under Section 8 companies which are with the charitable objects, they cannot appoint any other person as a proxy. Only a member will be acting as a proxy. A proxy can act not exceeding 50 and holding how much aggregate of the share capital? Not more than 10% of the paid up share capital. Now there is Mr. Ram who is holding 25% of the paid up share capital of the company. If you have appointed Mr. A as a proxy for Ram, this Mr. A cannot be appointed as proxy for any other person. Why? Because A can be proxy maximum of 50 members who are holding at least 10% of the total voting powers of the company. This Ram is alone holding 25% of the share capital. Then if you have appointed a proxy, Mr. A has been appointed as proxy. Dhanush says, ma'am, can you slow down a bit? Dhanush फिर रह जाएगा proxy देख लो. Okay, चल आराम से कर. पहले क्या है? Proxy is a person who is acting on somebody's behalf. If you are absent, you are sending your attendance somebody other person. Okay? Priya says, ma'am, this is too much for today. Okay, relax. थोड़ा सा पढ़ लेते हैं proxy. बाकी next class पे carry forward करते हैं. Okay? I know you are tired, exhaust हो जाता है, बहुत सारा पढ़ लिया है, so it's okay. Relax, we'll study a little bit and then I'll start from proxy again in the next class. But since we have time, let's complete it a little bit. So now he can be acting proxy maximum for 50 members. 50 लोगों के लिए वो proxy act कर सकता है, but those 50 members whose aggregate paid up share capital should not be more than 10%. So there is Mr. P, there is Q, there is R. They are having 3% of the share capital, 2% of the share capital, 1% of the share capital. So A can act as a proxy for all of them. क्योंकि 50 members के लिए act कर सकता है and paid up share capital 10% से कम. But there is another man, Mr. Ram, who is holding 25% of the share capital. Now, if you have appointed A as his proxy, then he will not be appointed as a proxy for any other person. फिर वो किसी और के लिए proxy act नहीं कर सकते. Okay? Yes, Priyanshi tak, absolutely agree with you. Good. ठीक है, यहां तक समझ आया. A member having more than 10% of the share capital may appoint person as a proxy, but then he will not act as a proxy for any other person. जो ये लाइन है उसका एग्जाम्पल ये वाला है, जो ये लाइन है उसका एग्जाम्पल ये वाला है. अगर आप 25%, 20%, 50% शेयर कैपिटल होल्ड कर रहे हो, फिर आप जिसको प्रॉक्सी अपॉइंट करोगे वो किसी और का प्रॉक्सी नहीं एक्ट कर सकता. निधि, आपने हिंदी में बोला था, समझ आ गया बेटा? In English, if you have appointed anyone as your proxy, then that person cannot be acting as proxy for any other person. Maximum limit for a proxy is 50 members having 1/10 of the total share capital. Appointment of the proxy will be done in MGT 11. So, in next class, mein dikhaungi MGT 11 form has to be filled when you appoint a proxy. Every notice of the company having share capital or the articles shall provide for voting by proxy. A member entitled to vote is entitled to appoint a proxy and can vote and attend himself. Proxy need not be the member. So you can appoint anyone. Notice will tell that who is going to be appointed as a proxy. Means now in my notice, I will write that Mr. A will be appointed as the proxy of my company. Is that clear? If you do not comply with these provisions, you don't tell that who is coming as a proxy, then a fine of 5,000 rupees will be charged. So it's very important. Company will have to tell that Mr. A is acting as a proxy. If company is not telling, then a fine of 5,000 rupees will be charged. A proxy form should be received 48 hours before the meeting, even if the articles provide for a longer period. अब 48 आवर्स हमने आज कहीं पढ़ा है? पहले मुझे बताओ. सो रहे हो सब, जाग जाओ, जल्दी बताओ. हमने कहीं 48 आवर्स के बारे में आज पढ़ा है? Was there any provision relating to 48 hours? Tell me. Yes, where the notice is dispatched by post, it will be considered as within 48 hours it has been received. Julie, Almaz, Naina, good. Yes, Soumya, he cannot be appointed as proxy for any other person. Mr. Sandeep, good. Kirti, excellent. Yes, 48 hours में notice पहुंच जाना चाहिए. यहाँ पे क्या कह रहे हैं? Deposit of proxy form. 48 hours पहले हमें proxy form deposit कर देना चाहिए. Instrument appointing a proxy shall be in writing and signed by the appointer. If it is a body corporate, then it shall be signed by any other officer or attorney. So it has to be in writing and shall be signed. If the invitation to appoint a proxy as a person or one or more other persons are issued to the company's expense. So simple बातें हैं, 48 hours पहले देना है, sign करना है and company के expenditure पे आपका proxy assign हो रहा है. A person who is appointed. इसमें important point ये है कि 48 hours पहले आप दोगे, even if the articles provide for a longer period. So that means if your meeting is on 1st October 2023, then 48 hours prior to the meeting, क्या हुआ? 30th September and 29th September. So 29th September 2023 तक proxy form आपका MGT 11 चला जाना चाहिए. You have to give it intimation to the company that this person has been appointed as the proxy. MGT 11 will not be questioned if it fails to comply with the requirements. So MGT 11 has to be filled in. Every person who is entitled to vote during the period of 24 hours before the time fixed for the meeting and at the time of ending the meeting can inspect the proxy form at any time during the business hours. अब इसमें ना सारा ही ये सिर्फ टाइम का ही है. प्रॉक्सी में कुछ ज्यादा खास है नहीं. MGT 11 भरना है, मेंबर नहीं होना जरूरी है. सेक्शन 18 में मेंबर, सेक्शन 8 कंपनी है तो मेंबर होना जरूरी है. 48 आवर्स पहले इंटीमेट करना जरूरी है. अगर आपने नोटिस में नहीं लिखा तो 5,000 रुपीज का फाइन है. 48 आवर्स पहले आपको बताना जरूरी है कि हु इज गोइंग टू बी अ प्रॉक्सी. अब इंस्पेक्शन कौन करेगा? Somebody wants to see that Shah Rukh Khan was a member of a company. Shah Rukh Khan said, I will not go and attend the meeting. Mr. B, you go on my behalf and go and attend the meeting. Now, members who are entitled to vote want to see who is Mr. B. Shah Rukh Khan ने किसको भेजा है meeting के लिए. They are curious to know. So now they can inspect. You have a right to see who has come as a proxy on behalf of a member within 24 hours before the time fixed for meeting. So our time fixed was 1st October 2023, 11 a.m. is the meeting. So starting from 11 a.m., 30th September 2023 से लेकर till the time meeting is concluded, you can go and inspect. You can see the proxy papers. You can read the name of the person who is appointed as a proxy because you're a member of the company. You have a right to see. कोई किसी मेंबर के बिहाफ पे आ रहा है आपकी कंपनी की मीटिंग अटेंड करने, तो आपको राइट नहीं है, तो आपके पास राइट है 24 hours before the time fixed for the meeting till the time the meeting is concluded. You can go and inspect during business hours. Only during business hours you can go and inspect who has come to see the proxy. Provided not less than 3 days notice has to be given. So 3 days notice will be given that we are coming to inspect the proxy. So if the meeting is to start on 14th March at 11 a.m., so the intimation has to be given on 11th March. If the meeting is starting on, so first point is intimation to be given 3 days prior. ये सबको समझ आया? Meeting is starting on 14th March at 11 a.m. So 3 days prior notice has to be given. So is it correct? 11th March 11 a.m. तक intimation चला जाना चाहिए कि हम आएंगे inspect करने. And कब inspect करेंगे? 24 hours before the meeting, that is 13th March, till the meeting continues. Say, for example, if the meeting continues till 6 p.m., then the inspection can be done from 13th March, 11 a.m. till 14th March, 6 p.m. I am not getting any response, which makes me feel that we should stop till here. क्या कहते हो? नहीं पढ़ना और? फटाफट से क्वेश्चन देखती हूँ आपके लिए कोई और है कोरम का. Okay, ma'am is also here. Let's ask ma'am to. Yes, ma'am.
Hello, good evening.
Good evening, ma'am. Welcome to the class.
Thank
Students
you.
are like, ma'am कि हमें और नहीं पढ़ना, हमने बहुत ज्यादा कर लिया.
हाँ, ठीक है, छोड़ दो बच्चों को, छोड़ दो.
I was trying to complete Proxy also, but then too much for today.
Good evening, Vemur, Janvi. बच्चे पढ़ना नहीं चाह रहे, थोड़ा चैप्टर भी बहुत लंबा है. Good evening, Soumya. Good evening. So, you leave the class, it's okay. But before that, let's have a rapid fire round. Good evening, Anushka. Good evening, Sandeep. Good evening, Sunil. Good evening, my dear students. Priyanshi, Kirti, Nidhi, Priya, Priyanshi, and ma'am proxy तो हो ही जाता within time. कोई बात नहीं. Proxy is a easy topic. You would be surprised if you have not seen the paper. इस बार का first case scenario is based on this section only. Section 105 जो अभी अपना कौन सा पेपर हुआ है बेबीज? Tell me. May 2025 का case scenario 1 was based on section 105. तो ऐसा करते हैं मैम, आप प्रॉक्सी छोड़ दो, मैं इनको फटाफट
they have done notice, explanatory statement, quorum, chairman, everything they have done today, and even
have they done 103?
Yes, quorum is
Quorum there. They have done, obviously they have done registers also. Annual return they have done.
Annual return they have done. AGM they have done. EGM revise भी करा इन्होंने आज.
ठीक है. So just 1 to 2 minutes and then you may close down the class, and before that थोड़ा बच्चे pep up भी हो जाएंगे. I'm just sharing my screen. Give me a minute. Oh God. एक सेकेंड होल्ड करिएगा. I'm not able to see my document. Okay. Hope so this document is visible.
Yes, yes.
Chalo. So this is a rapid fire round. So we are at 8:30. 1 minute or 1.5 minutes. Just don't tell me the answers. It consists of 7 questions. Let's see how many of you can guess it right in 90 seconds. So the quorum for a journal meeting of a private company shall be dash members personally present unless the article provides otherwise. Just write it. Next, if the quorum is not present within half an hour from the time appointed for holding the meeting shall stand dash unless otherwise provided in the articles. Every company shall file with the registrar a copy of the annual return within dash days from the date of the AG. The annual return of the company shall be filed in form number dash, because this is important form and it is very much, ma'am, I have seen that you have revised it under as per the company's rules, management rules. I'm not taking the name of them.
Very important.
Quorum for a public company with more than 5,000 members is dash members personally present. And the next is in case of a public company with members between 1,000 and 5,000, quorum shall be dash members personally present. In case of an OPC and small company, the annual return can be signed by the company secretary, or where there is no company secretary, by the dash of the company. 30 seconds more and then I will close down this.
I'm sure they're all going to crack the question paper very nicely. Very nice, interesting questions, ma'am, you have got. So you can write the answers appearing to everyone. Some of them are sending the answers to me.
No, I said I will now just tell the answers one by one. They're sending it to me also. Okay, I'm closing this down. I'm stop sharing first of all. Okay. But so they have sent it to me also. So the first answer is, ma'am. So
Yes.
the first answer is 2 members.
2 members. Rajveer, good. You have sent it to me, Rajveer, Sangeet Pani.
Ma'am, they will tell me the score.
Okay.
Okay. Out of 7, they will tell me how many correct. Then the next answer is postponed.
Adjourned. Adjourned, they have written.
Adjourned, postponed, both are correct. Adjourned is a better word, not dissolved. Dissolved cannot be a word. After all this is over, I will tell you, I agree that adjourned is a very better word. Postponed is not a better word. So during the examination, do not write the word postponed. Preferably write the word adjourned and not dissolved. Okay, the third answer is 60 days. Then number 4 is MGT 7. Number 5 is 30. Okay. And number 6 is 15 members. And number 7 is, who can sign it? The director. So 2 adjourned, 60, MGT 7, then 30 members, then 15 members, and
directors.
Director.
5 out of 7. Rajveer.
Okay. Good, Janendra. Nanya, good, Ishan. Very good. Send me the scores. Send me the scores.
Anushka is saying 6 out of 7. Rajveer is saying 5 out of 7.
I will send you across the score that they are sending me. We have just studied just now. That's why all corrected. Priyanshi, if your concepts are clear, na bache, it will be done, because I asked very easy questions. Such questions will not come in the examination, but it will keep your mind working in different ways. Very good, Sandeep. Any other student? And in the next class, whenever I will be taking the class, ma'am, with you, I will not ask the questions. What I will do, I will give them a question and ask any student the way we do it in class, and then they have to answer it. Very good, Miss P. So generally, the students are having Soumya, very good, are having a score of more than 90%.
Yes,
Right
5,
now?
6, 7 के बीच में.
Yes. So 10th or 12th का भी result आया. So I am talking in terms of percentages now, right now. Very good students, and ma'am, hats off to you that the students are doing so good. And students, do you have any query for BOS? Good, ma'am. बहुत ही बढ़िया बात है ये तो. Chalo students, today you guys are very tired. I will not take much of time. Thank you, ma'am.
Thank you, ma'am. So 19th, we'll wind up MGT. So come revised and prepared with whatever we have done so that we can quickly close the chapter of the last class. All right. Thank you so much, students. All right, ma'am. Thank you. Good night. Yes.